अस्सलातु वस्सलाम अलैका या रसूलुल्लाह वस्सलाम अलैका या हबीबल्लाह। प्यारे व्यूवर्स, उम्मीद करता हूँ आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह ताला आप तमाम दोस्तों को सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। He shall make a separate record of the statement of each such person whose statement he records. Commentary. Number 1. Scope and extent. Statement recorded not substantial evidence 1968 SCMR 161 PLD 1965 SC 1. Statement recorded in this section is inadmissible in evidence 2001 SCMR 14 delay of 1 day credibility not affected 1968 SCMR 161 police not recording statement PLD 1969 LH 114 copy not supplied evidence to be ignored PLD 1968 LH 694 omission need not to be provide 1971 PCRLJ 274 however benefit will be to accused 1971 DLC 87 PW given up statement under section 164 not to be used for corroboration 1970 PCRLJ 1104 authenticity PLD 1982 SC 286 credibility of witnesses is to be locked with serious suspicious if his statement under section 161 recorded with delay ELJ 2001 CRC Quetta 978 non-recording of statement of victim effect PLJ 1982 FSC 17 incumbent for the police to investigate on the receipt of information PLD 1969 PASH 109 statement before police during investigation inadmissible to in evidence 2001 SCMR 14 the statement before police during investigation inadmissible in evidence 2001 SCMR 14 the statement recorded by a police officer under section 161 even though is a previous statement under section 145 evidence actor can be used for the purpose of establishing a contradiction or impeaching the credit of the witnesses but only in the manner provided in section 102 AIR 1999 SC 2161 prosecution not to be permitted to confront or contradict its own witnesses with previous statement PLJ 2001 SC SH C AJ and K 39 statement under this section made during investigation of the case has got no value at all and such disclosure is not admissible in evidence and cannot be relied upon at bail stage 2003 MLD 261 statement of prosecution witnesses given to IO during course of investigation are not required to be recorded in the evidence through the IO as the same is inadmissible in evidence 2003 MLD 676 statement of accused at the earliest opportunity before the police during investigation carries weight PLJ 2005 FC 50 statement under section 161 CRPC absolutely inadmissible and cannot be locked into for any purpose, much less for recording, conviction, or any criminal charge. PLJ 2005 CRC PESH 7 DB given up PWS can be examined under section 540 CRPC. However, they can be confronted with their police statements in terms of section 162 CRC PLJ 2005 CRC LH 395 non-examination under section 161 CRPC attributes to incompetence of police and complainant cannot be confronted 2005 CRC PCRLJ PESH 119. Number 2 belated recorded of statement. Statement of witnesses cannot be brushed aside merely on the ground of having been recorded after some delay 2003 VLR 761. Such statement has no evidence value. PLJ 2005 CRC PESH 7 seriously debatable if delay not plausible explained 2001 PCRLJ 1766 PLJ 2001 CRC क्वेटा 1978. Number 3 nature. Statement under section 161 are not substantive evidence and can be used only for a very limited purpose of contradicting a witness at trial so as to prevent him from corruption his testimony by way of dishonest improvements at trial stage. NLR 2004 CRI PESH 168 no evidentiary value PLJ 2005 PESH 7. Number 4 supplementary statement brought on record by evidence can be read and considered along with FIR 2001 PCRLJ 1968. Number 5 issuance of processes. Process can be issued on basis of material percentage presented along with challan if court considered that justifiable grounds access to issue process 2000 PCRLJ 1679. Dying declaration. Number 6 dying declaration. Substantive piece of evidence if trustworthy 1992 PSC 108 SC statement of an injured person and admissible evidence PLD 1992 SC 211 contradiction 1990 PCRLJ 1765 delayed recording of statement without explanation to be ruled out of consideration NLR 1998 CRI क्वेटा 7. Number 7 statement by injured person. Statement given by injured person to IO and also FIR lodged by him is not admissible as dying declaration AIR 1999 SC 3883। Number 8, testimony of witnesses. Testimony of witnesses not recorded under section 161, not admissible 1995 PCRLJ 248 PLJ 1994 CRC 473, not a substantial piece of evidence 1994 PCRLJ 248, not nor legal evidence can be used by accused for contradiction 1995 MLD 1635, NLR 1994 SD 682, statement recorded after delay 1993 SCMR 559. Statement of all the witnesses recorded by the police in whatever form, whether in the shape of narrative or question answer form, or even in the form of condensed or summarized statements, are covered by section 161 1995 PCRLJ 1124. Witnesses cannot resile his previous statement PLJ 2005 SC 451. Number 9, purpose to enable the accused to prepare his defense. Accused has a right to confront the witnesses with a statement recorded under section 161 CRPC PLD 1996 LAH 286. Number 10, Zimnis. Zimnis recorded by IO during course of investigation, part of recorded under section 161 CRPC. Accused can demand copies of such statements subject to exceptions provided under section 162 CRPC PLD 1996 LH 277 PLJ 1996 CRC 307. Accused has right to receive all the copies of the statement of all witnesses recorded under section 161 in terms of section 261 in terms of section 265 C A 265 C under 1 C CRPC, irrespective of the fact whether they have the commencement of the trial PLG 2003 LH 290. कानून शहादत. नंबर 11, कानून शहादत. प्रोविजंस ऑफ कानून शहादत ऑर्डर 1984 are and independent of the provisions of criminal procedure code 1898, admissibility or inadmissibility of evidence, production of documents in impeaching the credit of the witnesses, etc. are the circumstances governed by Qanun Shahadat. Only the case diaries are meant to be treated as privilege and shall not be made accessible to the accused. Quote in terms of Article 1(5), Qanun Shahadat can force the IO to look into the case diaries to answer correctly the question put to him in cross-examination 2000 PLD 2003 LH 290. Number 12, evidentiary value. Statement of accused recorded under section 161 is not a substantive evidence and be used only for a limited purpose of contradicting a witness's at the trial to prevent him from corruption his testimony by way of dishonest improvements 2003 YLR 27. No evidentiary value PLJ 2005 CRC PESH 7 no weight can be given if eyewitnesses is murdered before recording his statement before court PLJ 2001 CRCP SH 861 PLD 2001 PSH 117 delayed examination. If the police did not recorded the statement of the witnesses and delay was caused in recording the same, then reasonable explanation is required to be furnished for such delay. 2006 PCRLJ 639 KAR। आखिर में मैं अपने तमाम दोस्तों का शुक्रिया अदा करना चाहता हूँ जिन्होंने मेरी वीडियो को शुरू से लेकर आखिर तक देखा, और ये रिक्वेस्ट करना चाहता हूँ कि मेरे इस चैनल को सब्सक्राइब कर लें। नए आने वाले दोस्तों से रिक्वेस्ट है कि मेरे चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। उम्मीद करता हूँ आप दोस्तों को आज की वीडियो के बारे में जानकारी काफ़ी सारी जानकारी मिली होगी जिससे आप फ़ायदा हासिल कर सकते हैं। बहुत शुक्रिया। अल्लाह हाफिज़।